Hi, this is Jered Dobbs. I'm an immigration lawyer in Dallas, Texas, and I'm here today to talk about adjustment of status. So thanks for tuning in, and let's dive right in. So today's topic is, what is adjustment of status? Well, simply put, adjustment of status is the process of applying for and obtaining your green card inside the United States without having to leave the U.S. and go to a U.S. embassy in another country. So if you leave the U.S. and go to a U.S. embassy in another country to get your green card, that's called consular processing. And I'm going to talk about that in another video. But today we're going to focus on domestic processing of green cards, which is called adjustment of status. So a common question that I get is, well, which one of these is better? Is adjustment of status better, or is consular processing better? One isn't necessarily better than the other. Adjustment of status is available to some people and it's not available to others. For many of those who cannot apply for adjustment of status for one reason or another, many of them can apply for consular processing. But in general, lawyers tend to prefer adjustment of status over consular processing for a couple of reasons. The primary reason is that adjustment of status is a more predictable process than consular processing in many ways. The timeline is more predictable. Additionally, adjustment of status typically allows an applicant to receive a temporary work permit while the adjustment of status application is pending with the U.S. Citizenship and Immigration Services, or USCIS as we call them. So let's talk about that adjustment of status timeline and the work permit. So adjustment of status is typically the preferred process, but it's not perfect. And there's a couple of quirks you need to keep in mind about it. Number one is that adjustment of status, in order to complete the process, it can take a year or more from the date you file your application for adjustment of status until the date you actually receive your green card. So that can be a really important factor for some people. There can also be some restrictions on traveling in and out of the United States, at least for a certain period of time while your adjustment of status application is pending. So you do need to factor that in as well. Additionally, when it comes to the work permit, the adjustment of status application does allow you to file for a temporary work permit that you can use while the application is pending for that year or more with USCIS. However, USCIS can be slow to issue that work permit. At least as of the date of this video, it can take 6 months or more for USCIS to issue the work permit from the date you file your adjustment of status application. So you have to factor that in to your plans when you're filing for adjustment of status, especially if you are needing to work sooner rather than later. So who can apply for adjustment of status? Well, there are many categories of immigrants who can apply for adjustment of status. Some of the most common beneficiaries are spouses of U.S. citizens, parents of adult U.S. citizens, unmarried children of U.S. citizens. Those are some of the most common ones. Some spouses of permanent residents or spouses of other green card holders can apply for adjustment of status depending on their circumstances. Additionally, there are many employment-based applicants for adjustment of status. That is, people who are being petitioned by an employer for permanent residence. Many of them end up applying for adjustment of status as well. So now a common question that I also get is, well, what if I maybe have worked illegally, or I've been in the United States illegally for some period of time? Can I still apply for adjustment of status, or am I going to have to do consular processing, or can I even get my green card at all? So there's some good news, especially for spouses of U.S. citizens, parents of U.S. citizens, children of U.S. citizens. Those three categories in particular have a very special exception in the law that generally will allow them to apply for adjustment of status, even if they have worked illegally and even if they have not maintained legal immigration status in the United States. Now, when it comes to other categories of adjustment of status applicants, such as spouses of permanent residents and employment-based applicants, Those categories tend to be subject to a lot more stringent requirements in terms of maintaining legal immigration status and not working illegally. However, even in those categories, there can be some exceptions, even if your immigration record is not entirely perfect. So it's always worth chatting with an immigration lawyer before you apply, especially if you have some blemishes on your immigration record. Now, another common question is about adjustment of status interviews. So the USCIS conducts adjustment of status interviews all day, every day. And they may or may not call you for an immigration interview. And much of it depends on which category you've applied in. So, for example, spousal cases are always interviewed. Spouses of U.S. citizens, spouses of permanent residents. Any adjustment of status applicant in either of those spousal categories is going to be interviewed every time. So don't read anything into the fact that you're being interviewed. That's normal. There are some other categories like parents of U.S. citizens, children of U.S. citizens. They may or may not call you for an interview if you're in one of those categories. If they don't, that's great. That means everything looks good, and what they'll do is just mail you your green card in the mail. If you are in a category like that and they do schedule you for an interview, you don't want to necessarily read anything negative into that. Typically what it means is they just need to clear something up, and by and large you go to the interview and everything goes fine, and then you receive your green card. That said, if you do have any kind of issues in your case, especially if you have criminal history, if you have previous immigration violations, or if you've ever had a unfavorable interaction with a U.S. immigration official, whether that's an embassy officer in your home country, an interaction at a U.S. port of entry like an airport, or at the U.S.-Mexico border or the U.S.-Canadian border, or if you have had a prior bad experience in filing for some kind of immigration benefit while you're inside the U.S., so any sort of adverse interactions with USCIS. And if you're then filing for adjustment of status, then typically it's going to be advisable to at least speak with an immigration lawyer before you attend your interview. You are also allowed to bring a lawyer to your interview with you, although it's not required. So when it comes to, well, should I bring a lawyer to my adjustment interview? It really depends. Many cases go through just fine without a lawyer, and much of that depends on your comfort level. If you have a clean case, no problems, some people are fine not bringing a lawyer, and that's perfectly okay. But as I said, if you have any kind of previous criminal matters, immigration violations, adverse interactions with any kind of U.S. immigration authority, definitely speak with an immigration lawyer before you proceed. If you'd like to reach out to us, our phone number is 972-855-8267. I'm Jered Dobbs, immigration lawyer in Dallas, Texas. This is the law office of Jered Dobbs, and we would be happy to help you with any and all questions regarding your immigration process and your adjustment of status. Thanks again for tuning in, and I hope to hear from you soon. Take care.